Hey IP friends, welcome to IP series with Rita. Yeah, welcome to IP series with Rita. My name is Rita Amrichinda, and if this is your first time listening to me talk about intellectual property rights such as copyright, trademark, patent, industrial design, trade secret, plant variety, and geographical indication, you are welcome to my episode. Please check out my previous episode where I talked about the Meta Voxer patent infringement case. Really insightful, I am sure about that. But for my returning listeners, you guys are the best. You guys are the best. Thank you so much for always coming back to listen to me. Now, straight to the good news. We are in our third edition of the IP series Christmas series. That doesn't sound right, but yeah, this is a Christmas edition, Christmas IP series edition, where I sometimes have guests over come talk about trendy cases, but they do just anything that my fingers can lay its hands on. So it's usually like a 12 series edition. I'm hoping I'm able to keep to it this year, but we are starting off with let's see. So this is a little bit of something similar to the previous edition, but this is from an expert's view. So I have a patent examiner who will be telling us everything about patent applications, what you need to know, especially within Africa. And so one thing I need to let you guys know about our guest for today is that we connected on LinkedIn. Please guys, take all your social media platforms seriously. You don't know who you might meet and how you guys can, help each other. Just learn how to network digitally. And that's how I came across Sammy. I think he posted something and he caught my attention and I saw his bio and I was like, oh my God, I need to get him on my podcast. And as God will have it, he was very accommodating and he agreed to come, talk on my podcast about what he does. So we set up a date and we got to record it. So I'm just gonna let him introduce himself. Sammy's from Kenya. He's going to introduce himself and tell you guys all about what he does, and then we'll just get straight into today's episode. So stay tuned.
Hi, Sammy Ziro, can you tell us your name, where you work, where you're based, and anything you'd like to share with us today?
Okay, thank you very much, Rita. My name is Sammy Ziro Lewa, and I'm a Kenyan examiner, basically pharmaceutical patent examination. And my work is to examine patent applications up to grant. I also do examination of utility model as well as industrial design applications. So specifically for the patents, I generally do examination to substance, basically examining its novelty. And in Kenya, we use absolute novelty, which means I have to examine and check whether the invention is new worldwide and also inventive worldwide.
Wow, that's interesting. So, would you kindly take us through like your daily activities? So, for instance, you have an application, be it is a utility model or design or a patent application. What would you, as a patent examiner, be looking out for basically from the applications before you?
Generally, we have different kind of applications that they hit on my table. So, like it's a patent application. We have those local applications, which by local I mean these are applications that they have been filed by Kenyans.
Okay.
And then we have the foreign applications, and these are applications originating from other countries through various routes. We have the PCT routes, which they come from the WIPO, which is administered by WIPO. Then we have the regional route, which they come from ARIPO. So depending on what the route is, these applications are different in terms of how they have been structured. But generally, I will be looking to formalities to check the paperwork that they have complied. So, for example, if it's a PCT application, definitely the applicant has to be represented by an attorney or an agent who is authorized to practice before the institute. The others are just normally the fees have been paid and that the formality issues. So once the formality or administrative paperwork has been an agreement, now I will have to check whether the claims are written properly, that they are being supported by what has been explained in the description. I will also want to look whether the client or the applicant has written the description in a manner that is enabled. That means somebody can be able to read and replicate the same. So the description basically is telling us how to carry out the invention, but then the claims is whereby now it is defense, whereby the applicants seek the protection. So the claims determine the scope of the protection. So once that one has been done, I go ahead and search the prior art that have or are likely to have disclosed the invention before the filing date. So once I do that, I search the WIPO database, the USPTO database, the EPO database, and once I come up with the relevant prior art for the regional applications, they normally ARIPO has a system which is called Polite. So when the applications are filed from in ARIPO, they appear on the web. I mean, on that we are using, we use a system called IPAS. Applications are being able to reflect on the other side. So basically, what we do, ARIPO had already done what we call an examination, and they attach a report. So for the ARIPO ones, we really don't do much. We just check on the report that the examiner has attached from ARIPO, and we check its compliance to our act. So one of the things that we check for the regional applications is the subject matter that the application is about. Is it a subject matter that is being allowed in Kenya? For example, is it a method of doing business? If yes, then we reject the application. Is it a method of treatment? If yes, then we reject the application. So as long as the application complies with the Section 21, we don't have a problem. We check on the claims, report, and the argument that have been raised by the examiner. If we are in agreement with the examiner's report, we accept the application and grant it, which means it will become effective also in Kenya. If we don't agree with the application and the reasoning that has been stated by the examiner from ARIPO, then we object it and then we give our reasoning. So majority of those applications that originate from ARIPO, we really don't have much of an examination because it's like going to be a repetition. So we don't do fresh examination. We just check the examiner's report if it is compliant with our act and whether we agree or disagree with the examiner's report. Basically, that's what we do with the ARIPO applications.
Wow, thank you so much for giving us a rundown of your day-to-day activity and also sharing insight as to how regional applications are done. Now, my next question is going to be, what is the timeline for registering a patent, either as a local or a foreigner in Kenya? How long does it really take to actually do a patent, get a patent in Kenya?
Receive a notification from ARIPO for the regional applications. The examiners from ARIPO will do the examination, and then through the DG's office, they communicate to member states, or not really member states, but designated states. Each application, the client designates some countries. So, for example, if the client has applied for a pharmaceutical composition, then in the application form, they will state or designate the countries. So assuming they have designated Kenya, Tanzania, and let's say Botswana, just for example, we as examiners or the country have up to 6 months, that is 180 days, to respond to that notification. Upon which, if a country or a designated state does not respond within those 6 months, ARIPO automatically grants that application and it becomes effective in that designated country. So I understand there are those countries who do not do examination, but for us, we respond before the expiry of 180 days and give us our objections. So if we give them objections, they have time to respond. If they respond, then we have another 3 months for us to respond to the arguments after the first objection. But in case we don't have an objection, we just go ahead and respond within the 180 days.
So once an applicant meets the basic requirement and gets his patent, how can, for instance, a patent owner in the pharmaceutical industry defend their patent against unauthorized use?
In Kenya, if an infringement, for example, occurs in the pharmaceutical patent application or a granted patent, the same way you can defend any other patent application will apply. So one, we have a tribunal. Then we have the commercial courts. So depending on the nature, first of all, we don't have a pre-grant opposition period. So if an application is published to notify the public that we are about to grant monopoly rights to this particular applicant or a pharmaceutical company, then the company will have to wait until that application is granted, and then they go ahead and oppose it. They can file through the opposition through the tribunal, that is after it has been granted, or they can decide to go to the commercial courts. The courts will constitute the bench of the relevant people who will hear the case. So that's basically how a pharmaceutical company can defend their patent in case of an infringement. If it is other IP rights having to do with that pharmaceutical composition, such kind like, for example, it is a patented product, but it's also a trademarked pharmaceutical company, they can also seek address from the anti-counterfeit authority, which is mandated to defend applicants in case of their infringement or counterfeited products.
Now, with all of these procedures stated to defend one's patent, how does the registry deal with generic patent applications?
I don't think the issues to do with generics will affect us much as to the office. However, we do have other bodies in Kenya, like the ones who are dealing with the standards, for example, the KEPS, and then we have the Pharmaceutical Society and the like. I might not be the competent person in terms of generic patents, but what happens is in Kenya, we don't grant patents for secondary use. So for example, a pharmaceutical patent has already been registered in Kenya for the treatment of cancer. But then the same compound, now you have discovered that it's also cures diabetes. No, we won't give you any patent for that. So yeah, that's it. The entrance of probably generic patents after or compounds after the expiry of 2020, I think that one is more of the society, the pharmaceutical society and other bodies, not necessarily us.
So, Sammy, what would you say is the format for registering a utility model or a design right in Kenya?
The format of a utility model will take the same format for a patent application. The way you will write, you will draft a patent application is similar to the way you will do it for a utility model. A utility model is what the USPTO is describing it as a petty patent. So, generally speaking, a utility model should be new, but not necessarily inventive. But the other criteria, as it's supposed to be supported by the description, the claims, everything is the same as a patent application, only that it's less inventive as compared to a patent. And in Kenya, we don't comment on novelty and inventive step for utility models. So it is upon the client to understand that whatever they are filing should be new. But in case we just discover that it is not new, we will still not comment about it. But we will give you a disclaimer that any person out there can actually do what oppose your invention should they learn that it is not new. So we leave the burden to the client. For industrial design for us is only for aesthetic articles. So an industrial design, the best example I can give is different water bottles have different shapes and configuration. Different phones have different shapes and configuration. So for industrial design, basically we protect the aesthetic features of an article. The way an article has been configured, is shaped, combination of colors. Yes, that one we do protect for industrial design. And the only requirement is to submit drawings for that industrial design, different perspective views, and we examine them. The Act also talks about absolute novelty for industrial design, but I think more emphasis is being given in general practice of what is existing in the database. So if we found that an industrial design is not registered in our database, we go ahead and register it.
I've been looking forward to getting an expert's opinion about the Moderna Pfizer case because it, was as a result of trying to find solution during the pandemic, the lockdown, trying to get vaccine. There were so many conversations going. We had the COVID-19 pledge. We had scientists volunteering some of their works to be experimented on, and then Moderna came to the rescue, and now Moderna is suing Pfizer for patent infringement of the vaccine. What is your view on this as a patent examiner?
My views on the Moderna and Pfizer case, I think generally speaking, when technology was used to make the vaccines, there was a need that people were dying, and there was the need that we should get treatment as early as possible. So the whole technology is based on the RNA, messenger RNA technology, which to me, I haven't really much understood the legal aspects of it, based on my background is on biochemistry and molecular biology. But I think the case is more about fighting the technology, not rather the vaccines. So, as a patent examiner, I probably would have how best then could they have dealt with during the early stages. They would have put too much emphasis on the technology and not the vaccines. So my views on this Moderna case would probably be to wait on the outcomes and see how they're going to be, because the technology, mRNA technology, which is the gateway to so many vaccines right now.
But my next question is, what is the statistics of registration for patent applications within the pharmaceutical companies or any other industry in Kenya, be it local or foreign?
One thing that you have to understand is pharmaceutical patent application forms the greatest. I don't have specifically, but the majority of the applications that come from the regional and international route, majority of them are PCT applications and they are pharmaceutical applications. They either be pharmaceutical or biotechnology. They form the greatest numbers. I don't have the numbers per se, but they form the greatest number of applications we receive.
Fantastic. So, in your opinion, as a patent examiner, I thought you were a lawyer.
No,
Trends, what patent trends have you noticed within Kenya and internationally, and also within the pharmaceutical space?
well, what I have seen in terms of the trends in pharmaceutical industry is that there's people are turning away from before this messenger RNA technology came into place. More emphasis was being given to compounds than methods. I think because of the fact that many countries do not accept methods of treatment in terms of patenting. So right now, majority of those applications that we receive, they tend to protect the compound itself and more or less the active ingredient. And these pharmaceutical applications, they majority come from big companies, which I can say the big pharma. And these are people who can be able to play around with words as long as to be able to protect their inventions. And this affects the whole range of access to medicine and everything. But you see, from an examiner's point of view, I have to ensure that whatever I'm granting is not something that is going to deny somebody a compound so that they can be able to get treatment. So, but basically that is that. The pharmaceutical industries or companies will make as much as more efforts to ensure that they protect the compound. But for me as an examiner, I have to make sure that I do as much as I can to make sure that they just don't protect something which is already just a manipulative compound which has already been existing, and as much as it's new, it's not inventive. So I have to create a balance between what I do and what the people want out there. But there's been the general trend of protecting the compounds so that they can be able to reap as much as possible. Majority of the applicants, again, are foreign applicants. Local companies, very, very few.
So, when you were talking, you made mention of access to medicine. Now, I know that compulsory licensing can be used to give access to medicine for low-income countries. What are your thoughts as to these applications that should emanate and also take into consideration developing countries that may not be able to afford it and want to apply for a compulsory licensing to create their own generic version or a lesser version of the existing patent?
My question would be like this one. Okay, during my almost 10 years working at KIPI, I haven't heard of any pharmaceutical that has been for compulsory license. But then the question will be, even if a company applies for compulsory license, then the company has to be in a position to manufacture the same. My question is, do we have the companies here that are able to, let me, for example, if Moderna right now decides to give, there has been the debate that African countries or least developed countries should be given the mandate or should be waived those COVID waivers, blah, blah, blah. But the question is, do we have the capacity to manufacture even if we are given the compulsory license? Because the government goes ahead to issue a compulsory license because probably there's the need, or maybe the pharmaceutical company cannot be able to produce enough on its own. But so far, we have not come to that. But the provision
Okay.
for computer license, yes, it exists in our act. It's probably when time comes, it will be used. But at the end, the question for me as an examiner and generally as a Kenyan is, do we have the capacity? I don't think we have the capacity because it remains, again, it goes back to those big companies that they are the owners of the patents, pharmaceutical patents. But then if we go ahead to issue compiler licenses, for the sake of who? Unless it's the government itself.
So final question, and then we'll wrap up. Would you say it's right for a patent owner to sue for infringement just to get profit, especially when the IP was created to solve an emergency, just like the in the COVID, when we had the pandemic and the lockdown? Would it be proper to later on to sue for infringements just to get some royalties?
I believe any person who has invested money has a right. If we discuss the aspect of like, is it moral, upright, or is it okay? Then probably, if we go that direction, then people will not be able to do research and development, and where will they get the money?
True.
So for me, I think they have every right, and maybe it's a wake-up call for governments to fund more research in those areas so that we don't have those issues of independent researchers having to sue you every time you infringe on their product, because they have spent a lot of billions of cash in doing research and development, and clearly the patent system was established to take care of them.
Fantastic. So, any final words from you as a patent examiner to anyone listening, and final words in how we can reach you if we want to get you back here or contact you later on?
Uh, what I will tell every person listening and who wants to promote IP rights in Africa, probably we should start by people understanding how to draft patent applications.
Okay.
Because I have realized that majority of those inventors from developing countries or least developing countries, we have the knowledge, but we don't know how to put it in a correct format for patent examiners out there to be able to grant those patent rights. So at the end of the day, you get that you reject an application not because it's not novel, but maybe because it has been poorly drafted.
Hmm.
Yeah, so that's an area probably a lot of patent attorneys should take care of it. Those on the southern side of like Adams and Adams and the like are fine as much because our South Africa system is uh, more into those drugs. But generally speaking, in Africa, we need to uh, up our game when it comes to patent drafting, especially for the locals. On how to reach me, you can always reach me at patentlykenyan@gmail.com. So I'm saying you can be able to reach me on Twitter. Basically, it's at Leziro, Leziro. On LinkedIn, you can just search Sammy Ziro Lewa, you'll find me. On email, you can get me at patentlykenyan@gmail.com.
So you were saying we can reach you on Twitter. What's your Twitter handle? I'm not sure I'm following you on Twitter.
Yes, I'm on
What's your
Twitter.
Twitter
I'm
handle?
at Leziro, at Leziro.
Leziro.
Yes, at Leziro.
For
Yes,
the
I am.
network glitch again.
All right,
But
no
it's been a
problem.
pleasure talking to you.
Thank you.
All right, IP friends, we've come to the end of the Christmas IP series first episode for the year 2022. Thank you once again, Sammy, for coming on this episode to discuss about your role as a patent examiner and intellectual property right in the pharmaceutical industry. Now, if you have more questions for Sammy, just like he said, you can find him on Twitter, on LinkedIn. I found him on LinkedIn, so you guys can reach him out. Also send him an email if you have more questions, or if you have patent applications you need to do in Kenya, reach out to Sammy as well for guidance, I think. But yeah, if you have more questions about intellectual property, you know where to find me. And yeah, we're done for today. Cheers and see you in the next episode.